Do you devote your time, talent, and treasure to that case, or do you punt that case? Because you know when it's Walmart, you know what you're going to deal with. Very assertive defense counsel. They're good people. They really are. They're just advocates doing their job. But then you know you're going to file it in state court. You're going to get removed to federal court. Your client's going to get beaten senseless during deposition. They're going to be unhappy. And then you're going to go to that settlement conference, and you're going to get beaten in the head. You're not going to be happy. And then ultimately the case will probably get resolved. But really, again, is it worth the time, talent, and treasure to take those cases? Now, the most important day in any premises liability is that first day, when that client comes into that office. You know, if you don't like your client, you don't believe your client, okay, the jury's going to know that, the claims adjuster's going to know that, the defense lawyer's going to know that. Don't take that case. Also, don't take that case if the client can't tell you specifically what it was that caused them to fall, the defect. You know, if the client can't explain to you what the defect was that caused the injury, then how are you going to explain that to the claims adjuster or to the defense lawyer? Simply, you're not going to be able to do so. And it's that very first day when that client comes in and tells you exactly what happened. You know, if you're not 100% on board and there's not substantial injury, don't take the case. But with respect to the client, you've got to know everything about the client, their physical condition, medical treatment, any other conditions they may have had, knowledge of the premises, how often they had been there, what their knowledge and notice was of the condition that eventually caused them to be injured, what kind of clothing they had, the shoes they were wearing, their vision. Thoroughly understand the incident. Know everything you can possibly know at that point. And as soon as you learn it and you accept that case, confirm it. Go out to the scene, and we'll talk a little bit more in detail about that. And thoroughly understand the defect. Now, other than notice, do we all have issues about notice in premises cases? Yeah. Well, the second big hurdle that we have is establishing the reasonable standard of care under the circumstances. And there's several ways to do that. The most obvious way is, you know, Walmart and Kroger's and Marsh, they have a corporate policy. Is it difficult to get those? Yeah, they don't want to give them to you. But they have the corporate policy and procedure manual. It goes A to Z on how to operate the facility, how to maintain the facility, how to protect the safety of the people who go to the facility. Get that. That is the reasonable standard of care that they should have and they should follow. But there are also standards. There's codes. There's ordinances. But before you use any of that stuff, and we'll talk in great detail about it, you've got to know the common law. You've got to know exactly what it is that you have to prove, either by way of looking at the jury instructions or setting forth your burden of proof.